Just waiting for people to filter in. Okay, I think we'll get started while people are filtering in. So good morning, everybody, and welcome to part 2 of our Attorney Broker DR Roundtable. I'm Mary D'Ambra, South Shore Realtors President. So we have a couple of housekeeping items first, which is number 1, this is being recorded, and you'll all have access to the recording after today. It will be sent to you. If you have any questions or comments, you can put them in the chat. We'll try to get to as many as we can. We already do have questions that people sent in, but definitely use the chat to add any comments or additional questions. And as always, you have to be mindful, all of us, of antitrust, as we are all competitors. So don't discuss any specific pricing structures or business practices. So we'll have to stop if you're doing that. And we have Catherine Taylor from MAR here. She's our security, I guess, on that. Our South Shore Realtors Director of Professional Development, Marie Souza, will put the panelists' contact information in the chat, so you can all have their contact information. A lot of them teach CEs and have blogs and Facebook Live and other such platforms where you can increase your knowledge or follow up if there's something that you're still a little hazy about today. So let me introduce our panelists. First, we have Catherine Taylor, Associate Counsel at Massachusetts Association of Realtors, and Catherine handles the legal hotline. So an awesome resource that you all have access to, and she has a lot of knowledge and really can combine your code responsibilities with your legal responsibilities. So welcome, Catherine. Then we have Carla Goodale from Lieberman Law. Thank you, Carla. And we have Brad Mahoney, Mahoney Law Group, and we have Mark Stiles.
Morning.
So, okay, we're gonna, again, we have a lot of questions. We're gonna start out with Marie Souza is going to put in the chat the link to the recording from the first part 1 of this series that we did, because there's a lot of information in there that you can access that might build on what you hear today, or there could be some new information for you in there. So that will be in the chat. It's also on the launch, so you can get it either place. We're going to start out with one of our favorite subjects, which is love letters. So we did talk about love letters quite a bit in our first webinar, but there's still a lot of questions, and there has been a really lively discussion going on our South Shore Realtors platform, the launch, about the fact that the state of Oregon has banned love letters. So that's kind of brought up a lot of new discussion, and so they're not illegal in Massachusetts, but we can all tell you why they're not a good idea. And MAR has come out with some new forms that can help you with this subject. So I'm going to turn it over to Catherine to explain about the forms.
Yeah, thank you, Mary, and happy to be here with you all again this morning. 2 of our new forms that we have introduced to the MAR Forms Library relate specifically to love letters. The first is called Seller Instructions Regarding Buyer Letters, and it's exactly what it sounds like. It is a 1-page document that goes, helps facilitate that conversation with your seller clients about why reading personal letters from buyers is potentially dangerous from a fair housing standpoint. It reviews what fair housing law requires, what are the protected classes, and then it includes a signature line at the end for the seller to sign, instructing you as the listing agent to not accept personal letters from buyers and to place an instruction in the MLS that letters will not be accepted. And then we have a sister form to that that's called Fair Housing Considerations Regarding Buyer Letters, which is just sort of the flip side of that coin for your buyer clients to help explain to them why personal letters from buyers should not be used, and to facilitate that fair housing conversation with your buyers, and to inform them that you will not be participating in the drafting or passing of those types of personal letters. So those are being rolled out into the various platforms that the MAR forms are currently available on. I believe they are live in Dotloop, DocuSign, and SkySlope. They are in process in Form Simplicity and Zip form. So they should be available everywhere very shortly, but if you need them in the meantime, certainly feel free to email me. I have the PDFs of them. They're not fillable, but you can certainly use them if they're not available on the platform that you currently have. I'm happy to answer any questions about them as well.
Thank you. And, great that MAR has recognized that that is an issue and provided something for all of us to, help us navigate through that. Does anyone else on the panel want to make a comment about the love letters, or give a point of view of from where they stand?
So I said it before, I'll reiterate it in case there is new people. So we understand that everybody's trying to find their competitive edge. And funny enough, after this panel, I think it was after this panel, I had a new one come over on an offer. So the offer included a barbecue going away party for up to 30 people paid for by the buyers or the sellers, to say goodbye to their neighbors and everything. And the buyers were going to come and meet the neighbors and say, we're going to take care of this house and be a good neighbor to you, just like these people were. And a $200 gift certificate to some puppy daycare / grooming place of their choice for their 2 little dachshunds. So that is how they went ahead and decided to differentiate their offer. If you don't understand why love letters are problematic, that's another conversation. But what I had said before, and I hold true to it, and I'll give you 2 examples as to what's just happened in the last couple of days, is if you want to differentiate your offer, not so much to the sellers, but more to the listing agent, is when you send over your offer, have your team in place. This is our home inspector. These are the 3 times that they can already plan on coming. This is our attorney. Here's their contact information. They know that an offer will be accepted. If our offer is accepted, that the P&S date is such and such, and they are available. This is our loan officer. We've already discussed with them the closing date, the mortgage commitment. They are on board with this, so that the listing agent can convey to the seller, this is a very not only personally qualified, they can afford it and everything else like that. Their team is in place with the dates that they've put forth. There are not going to be any delays because, oh, the attorney isn't available, or oh, the loan officer just said, nope, we need at least 45 days, or anything else like that. So it's more a love letter from agent to agent to say, me and my team are ready to go if you accept our offer, path of least resistance. I had 2 different deals come over this weekend. Both P&Ss are due today. Buyer has still not selected an attorney. So, and then one of them, the buyer's agent has already come back and said, oh, we spoke with the loan officer, and there's no way that we can close on the 13th. We're going to have to push it out at least 10 days. So now we have an accepted offer, and we already have 2 dates or 3 dates. The mortgage commitment date can't be met, the closing date can't be met, the P&S date can't be met. So we have 3 dates that, poof, like what? And part of the attractiveness of the offer was that it was going to close very quickly. So these are the sorts of things that, in place of a love letter to help differentiate yourself, that you can help rise to the top if the agent understands what all of these moving parts can do to their client. And maybe it does end up becoming a money thing, because if you have to delay another month and you have another mortgage payment, and you have, in the winter, or you have another oil payment or something, that's some serious money. That's real money out of people's pockets.
I totally agree, Carla, and I think that's good advice for a buyer agent. Again, a way to distinguish themselves. I think also, I would say as a listing agent, when I have multiple offers, I put the offers on a spreadsheet. I think most people do that. And I have all the important information from the offers consolidated into that spreadsheet. And the columns that I have to do with, what are they paying? How are they paying? What other terms are there? And I do have a column for the buyer agent, which is where I put that type of information that comes in. So, I don't have a column for whether the buyers are married or what religion they are or what holidays they celebrate or where they say they're going to put their Christmas tree, right? All the things that come in a love letter, none of that goes into my spreadsheet. And, because it's not relevant and could lead to, a violation of fair housing. So, that's kind of where I sit as a listing agent. I advise my seller clients not to review them. That's always where I am.
And Mary, I would take that even one step further, and maybe you do this on your spreadsheet as well. But if you're using the spreadsheet to show your client those objective terms, have a final column that says, what was the decision-making process that either led the seller to accept or reject this offer? Because then you have something documenting the decision-making process that if someone were to come forward and say, my offer was the highest and I belong to this protected class, this must be a fair housing violation. You can then turn to this as evidence to protect yourself and say, well, although you do belong to a protected class, that wasn't considered in the decision-making process. This is the objective criteria we use to make the decision.
Good point. Okay, so I think we can move on from love letters unless anybody in the chat has any question on it. So this is a question that came in from during registration. And the question is about regarding disclaimers in MLS, buyer/buyer agent to do their own due diligence. So, we all see that, we agents see that in MLS, and this person wants to know your opinion on what does that really mean? Buyer/buyer agent to do their own due diligence. Any takers?
I think it's clearly stating buyer beware. We're not making any disclosures, but as we've talked about previously on this, and Catherine, we've spoken about transparency and the ability to, let the market know what this house actually is versus not giving any information. We had a situation recently, again, in this competitive marketplace, waived home inspection, did do one for informational purposes, but looked back on a disclosure where, for lack of a better term, a half truth, right? So back in 2017, we got water. We made diligent repairs. We had some storms recently. The person's upset and doesn't believe that disclaimer. So it is a very challenging decision of how to disclaim, right? But in this market, when buyers are willing to buy way over what the seller is asking, why not disclose that we've had water, so that after the fact, these folks who are waiving home inspections are looking for, who may have valid disputes with the seller, why not disclose it? Here, they're taking the total opposite, which again, Catherine can opine on this as well, is saying buyer beware. We're not saying anything as is. Banks do it all the time, right? If you have an REO, a buyer at an REO listing, we didn't live there, we don't know anything about it. Here's your 50-page purchase and sale agreement disclaiming everything. It's a strategy, but it's also, what's fair and equitable to a buyer going into it when everybody wants the same thing, a smooth transaction from one owner to another.
I think this, so how I read this question is, I'm a buyer agent and I see that. how do I mitigate the risk for my client, the buyers, but also for myself as a buyer agent?
Yeah,
You
I
know,
think that the question really becomes, what does that mean in the sense that what should I be asking? Well, is it on septic? Go down to the town. Am I supposed to be tying into town sewer? You know, is that something that upon sale it needs to happen and sellers didn't know? And you know, that was something that happened to me. It was in Brockton of all places. It was still somehow on a private sewer, and afterwards they were like, you need to pay us $15,000. And we didn't know we had to tie in. Have permits been pulled? Are there open permits? Who did a well water test if it was necessary? Did you do one? If not, like, you need to ask the questions. Did someone die there? Have you had water? Like, the seller doesn't have to disclose in any sort. I mean, yes, there's the lead, there's certain things that are required by law, but other than that, sellers don't have to tell you anything. So, you know, I have one agent that I work with, there's probably 50 questions in 8-point font, and every single time the offer is accepted, he sends that over to the sellers and is like, I want answers to all of these. So he's, you know, and he'll show it to his buyers and he'll say, are there any other questions that you can think of? And he puts that in an email. You know, I think that the thing is, in this market, to protect yourselves as agents, one, you need to memorialize everything that you're doing. Text messages and phone calls are great, and I love a phone call. The next thing needs to be you follow up with an email that's memorialized. The other thing is that I was talking about this with some people yesterday. It had to do with, you know, the agent told me I had to waive XYZ. Did you say, yeah, you need to waive it to get your offer accepted? Or did you say something a lot more thoughtful and fleshed out that said, as discussed before, this is a competitive market. You would have the option to waive these things. I do believe in this situation. I would advise you that way. Ultimately, it's your decision, you know, and you do the protection. But as an agent / buyer, you're the agent. The buyers are looking to you for guidance. They don't even know what they don't know to ask. So if work was it done by a licensed professional? Do we have receipts for that? What was done? Do you want a second opinion? Again, but you know, these are all great things in a regular market, but when it's a super competitive market, sellers are going to probably start looking at these things and be like, I don't need someone causing me problems. Let's just move on to the next one. So what I've advised agents to do on intake, when you're that first meeting, when you're doing the mandatory agency disclosure, I think that you have something typed up that also talks about, this is the market. This is what we're doing. This is how quickly it's moving. These are the different things that would have an opportunity to waive. We can look at those on a per house basis and decide if you are going to do it. Ultimately, it's your decision. These are the things that you should be talking to town hall about if you have questions on, and give them something up front that kind of sets the stage of like, this is what may happen, and we will make the decision on a property by property basis. But when it's as is, that means if you have a question on something, you better be asking, and if not, buyer beware, buyer buys, not the seller's problem once that deed's recorded.
Anyone else have anything to add to that?
I'd just like to add, I mean, they're all good points. I think an important part is having a good real estate attorney on the team, because some of the items that Mark and Carl introduce, if you have a good attorney who's experienced, their rider is going to bubble up any of these issues, right? So if you as the agent, it's a lot to put on you as the agent, especially in this market. You got to ask all these questions, do all this due diligence, and it's falling on you as is. And granted, you do have a responsibility to your client, but if you have a good attorney who's putting in representations of the seller that no work's been done without permits where permits are required, there's no underground fuel tanks, your lender doesn't require flood insurance, there's no U fee in the property, all sorts of things. It might cause a fight. And what you get a lot of times, the most common one I see is on unpermitted work, and you put that in and they're like, well, we don't know. I'm like, I'm not going to go with that one. We're just asking actual knowledge. During your ownership, did you do any work without permits where permits are required? And I feel you can really kind of tell if they're so staunch on not answering that question, unless it's a probate situation where they never occupied, I think they're hiding something. And you know, the devil's in the details, and sometimes a non-answer is the bravest answer, right? So that's the way I look at it. I mean, in all honesty, in this market, a seller just has to, in any market, a seller just has to disclose their knowledge of lead, whether or not it's septic or sewer, and then they just have to answer questions honestly. So feel free to ask questions. They might say no, but if you have questions, has there been flooding? You know, do you have knowledge of whatever? Ask those questions. And there's no requirement, as everyone I hope knows, there's no requirement to fill out a seller disclosure. And I might run counter to Mark on this, and I'm probably a little adversarial in the way I run deals, but I always tell sellers, don't fill it out. You don't have to. Why would you open yourself to that?
Agreed. Don't fill it out.
So
It protects the agent. Sorry, agents, it protects you guys, but it's not good for the seller.
So Brian, Elise is asking to the panelists, you know, and what your opinion is. So about sellers disclosures, he's making the point that on the North Shore, they're very common, but on the South Shore, we really rarely see them.
Well, I never go to the North Shore. No.
So it seems the consensus is you would be advising your sellers not to fill them out. I do think for myself as a listing agent, when I've sat with sellers, you know, the form itself presents some challenges, the way that the questions are asked. I've had, you know, a married couple trying to fill it out together, which, you know, was about ready to go next to divorce court over their, you know, recollections of things, or again, how they're reading the form itself. So I think it is challenging, but I believe most of the attorneys that I've talked to say the same thing that you all are, which is the advice is not, you know, to fill them.
I think the point to that, to continue what Brad said, is that it's not that us attorneys are so against them just on its face. It's that people don't remember, and they're just
Right.
kind of filling it out willy-nilly, thinking like
Yes.
it's not a big deal, but that's something that could be sued on eventually, potentially.
Yes.
And you know, most of our writers say, oh, you know, the
Right.
seller, any seller's disclosures, but there's still the point that it could be, you know, resurrected in court as a material fact that you relied on, you know. So the fact of the matter is, what I like to do is, when I was an, you know, agent, I would take that form and then just say, I would kind of ask the questions, but not have them fill it out. And if they didn't know, and I would have a separate Word document that I was like, okay, they said roof.
Unknown, yeah.
Actually have a receipt of, if you don't know the unknown, you know, like sort of thing. Because I always use my parents' house in Florida. They built the house in 1974. Do you know how many houses how many hurricanes have hit that house? If you ask my parents, have you ever had water? How many roofs have you had? They have pretty good records, but they wouldn't know. So if you've owned the house for maybe 5 years, yeah, you might actually remember what's going on in the house. You may know. You've owned the house much longer than that. Let's all admit, you're probably not remembering. So why not provide a document to the buyers of what your seller does know, and leave out all that other stuff that they don't really know, or they don't have a meeting of the minds of what the facts really were. And then you're giving what they do know. And that's all you're giving. And you're not opening yourself up from a seller to a.
Well, as soon as someone, you know, elaborates, I mean, yes and no, or I don't know. I guess those are fine in most, you know, cases. Yes, no, I don't know, right? Like you're in court. But as soon as they start writing, you know, that's when you see there's room, right? For, well, I took that to mean this, and, you know, the seller really meant that. And I feel like that in my early years as an agent, when I worked for a company that required them, those were the things that I experienced, that sellers would disagree on what they remembered. They would write, they would fill it in and elaborate on a certain point. And even I didn't understand what they were writing, and have to say, well, did you mean that you got water then, or that you know, fixed it, or that, you know, your sump pump failed? It just really, the more they wrote, the harder it was to figure out. So Brian is saying, if the sellers write to the best of their knowledge, wouldn't that protect them? To the best of my knowledge this, to the best of my knowledge that. What do you guys think about that?
I mean, maybe, but it also is a little bit useless to the other person on the other side. Like, what does it mean? Are you telling me the truth, or, you know, so you got to look at it sort of in perspective, right? Like,
I feel like every time I ask someone how old their water heater is, it's always wrong. And I don't think that it's in any way intentional. I just think it's one of those things that you're like, oh yeah, remember we replaced our water heater like, and they think it was 2 years ago, but it was really 12 years ago. You know, I think it's hard to remember that kind of stuff unless you're a person who keeps every receipt in a log or something.
So I saw 2 questions come in through the chat on
About the
MAR
forms.
forms. So I'm just going to touch on that really quick. So I've been sitting fairly quietly because MAR does not have an official position on whether you should or should not use the seller disclosure of property condition. We have it available in our forms library, both for residential and commercial properties, to be used at the seller's discretion. It's not a mandatory form, so it's something to have a conversation with your client about whether they want to provide that information. If they are using it, it is critical that it be filled out by the seller and not by you. You should not hand it to them and say, here, fill this out and get it back to me when you can. Sit down with them and explain them, walk them through the process, but make sure it's them answering the questions and completing it, and you're just there to help them understand what exactly all of these things mean and to counsel them on what their legal obligations are. And the flip side of that, buyer agents can certainly turn around and say, hey, seller, fill out this disclosure, or ask all of the questions on their own form. So there's nothing to prevent those questions from being asked by a buyer also. So we don't have a specific position on whether you should or should not use it. It is certainly a tool that helps protect you as a real estate licensee in Massachusetts, as far as ensuring that you are fulfilling your disclosure obligations under Chapter 93A. There's a different obligation for home sellers than there are for licensees. So that's important to remember as well, that any material defects that you're aware of need to be disclosed, whereas the seller doesn't have that disclosure obligation, but you as a licensee do. Finally, with regard to the question on the home inspection waiver form, that is another one of our new forms. There's a home inspection waiver addendum that is also being added to the MAR forms library that does reiterate the fact that buyers have the ability to obtain a home inspection. It's recommended. However, the buyer has made a decision on their own to waive that inspection, and they are waiving any potential future liability against the real estate agents involved for information that may have been discovered through performing an inspection. So I think that's going to be really useful, particularly with the marketplace that we're currently operating under, where home inspections are getting waived all over the place. So that helps provide our members a little bit of protection in those situations. Just make sure that you're not saying you need to waive the home inspection, because that form's not going to protect you if you do that.
Good point. And again, wonderful that we have these new forms to, to help us. So the next question is about how to cover yourself. Okay, so what steps should you be taking when you're working with an unrepresented buyer? And and so obviously surrounding procuring cause, because part 2 of this question was, then what do you do when an agent appears later down the road?
I can start that one. I don't want to hog the mic, so
Go for it.
You can tell me to back off if you want.
No, go.
So when you're working with an unrepresented seller, there's no obligation to enter into an agency relationship with them. You can work with them solely as a consumer, and then you still owe your full fiduciary duties to your seller client. You still need to provide that unrepresented buyer the mandatory agency disclosure that says, I am representing the seller. So you still need to provide that saying how you're operating in the transaction. You still have to treat that buyer honestly and truthfully and make mandatory disclosures to them and properly account for funds. Aside from that, you don't owe them any duties. You're really there to represent your seller's best interests and move it forward. What was the second part of that question?
So part 2, this is, all of our favorites, right? So you're a seller agent, an unrepresented buyer comes to you, you've filled out your agency disclosure, properly, as you just explained. and you're working with this buyer and you've gotten to some certain point in the transaction, and all of a sudden another agent appears who claims representation of this buyer.
So a buyer's always able to have representation. That is certainly their prerogative, and they can bring somebody in at any time. You're obligated under the code of ethics to cooperate with that person. That does not obligate you to compensate that person. So, you know, that's certainly something that can raise a question if somebody comes in midway through the transaction of, you know, whether you're going to be obligated to compensate them. You do want to be very careful to make sure that any discussions related to compensation of that buyer's agent don't interfere with the transaction, because then you're going to be in breach of your fiduciary duties to your seller if your interest, i.e. the money, the compensation, is outweighing your duty to represent their best interests in the transaction. You can have a conversation with that buyer's agent and say, you know, I know you came in late. I'd be willing to offer you X, or I'm not going to compensate you as contained within the MLS because, you know, you're not the procuring cause of this transaction. And you can certainly enter into your own agreement between the brokers as far as compensation for that agent who came in later in the transaction. And that can be any amount as agreed upon. Or if you're unable to come to an agreement, continue to facilitate the transaction through the end, through closing, and then you can resolve it following closing, whether it's through mediation or arbitration or independently. But it's critical to make sure that you don't let it interfere with the transaction.
I think the question probably brokers have on this, because I know I had an experience with this, was, yes, the deal needs to go forward, the deal needs to close. The brokerage, specifically if it's, you know, the listing brokerage, wants to know, okay, we know that our person gets X. Now there's the other Y. What do we do with that? Do we pay our agent? And then if, you know, arbitration mediation panel decides that there was compensation, that, because I know that there's no like splitting the baby. It's like there's winner takes all in this, you know, once it goes to that. Do they hold on to the other, whatever amount it is, until it's been, you know, what do they do? Because I think that the procuring cause a lot of times, and your operative word was, you know, when did you come in? Was the offer signed, you know, at the open house sort of thing? Not that that really happens anymore, but, you know, and 2 days later you found out before home inspection or anything else like that, that there was an agent, and they're like, yeah, you know, I was emailing my people all the time. Or you all of a sudden found out, well, I haven't talked to my agent in 6 months, but all of a sudden the agent's like, hey there, heard that we're at P&S, or heard that my client signed P&S, you know. It becomes that sliding scale of what and the you know, it's going to turn on the facts every single time. Who is procuring costs, and who's going to win that fight? So Catherine, can you speak to maybe what the broker should do if there is a dispute as to who should be getting paid?
Yeah, so always the baseline is that compensation is between brokers. So ultimately the determination is the broker of whether they're going to pay out to a cooperating broker and in what amount, or, you know, whether there's an agreement or through the MLS. So that's between the brokers. The agents can be involved in those conversations, but they're not ultimately the ones who are making that determination. If there is a legitimate question of procuring cause, I think it's a best practice to hold that cooperating broker portion of the commission in escrow until it's resolved, because once that money is paid out, it's very difficult to get it back, particularly if you pay it to a salesperson, and then, you know, it can get really messy really quickly. So I think that if there's a legitimate question, or if there's you know, a potential of it going to arbitration, it's a good idea to hold it until it's resolved, either through mutual agreement or through arbitration. Because like you said, Carla, it is, every situation is so different, and you have to look at all of the facts. It's not necessarily, if an agent wasn't at the first showing, it doesn't necessarily mean they aren't the procuring cause of the transaction. It depends on a whole lot more surrounding it. So sometimes it's not easy to make that determination. So I think if there's a question, you should hold it.
What are your thoughts?
You're not legally required to. I mean, that's the thing. But if you pay it out and then it goes to arbitration and they say you actually owe the cooperating broker, then either the broker who paid it out needs to try to get it back from their agent, or it's coming out of their pocket. So, you know, you can make your own decision as far as what you want to do. I think it's a best practice to hold it.
What are your thoughts on referring that buyer to another agent in your office to try to stop?
My thoughts?
No, Catherine.
I mean, whether you want to refer, I think transactions tend to move more smoothly when there are professionals involved on both sides that know the process. And particularly in those situations, if you're representing a seller and there's an unrepresented buyer, that buyer is going to be coming to you, asking you a lot of questions that you shouldn't be answering because you can't be counseling them. And then if you say something wrong, you could either be in breach of your fiduciary duties to your seller, or you could be overstepping and operating in a dual agency capacity that's not appropriately disclosed. So there are lots of potential pitfalls to it. So I think, you know, a lot of times, and not all buyers want representation. You can't force a buyer to work with somebody, but if you can say, all right, let me refer you over to, you know, so-and-so, they're great to work with. And if you're in a designated office, you could, you know, do it within your office, or you could do it to somebody else. You know, I think it's a personal decision, but if you don't, you need to be careful of the potential pitfalls.
That is very good advice.
Mary, quick
Catherine.
question for you. I don't know how many questions we have, but this whole buyer agency thing, I know, is it Illinois or New York? I can't remember now. Some state just made buyer agency compensation illegal. Yeah, so okay, if no one knows what I'm talking about,
No.
yeah, I'll have to find it for another time. I just didn't know if, you know, if we saw anything going. Yeah, somewhere determined that it's gonna be taken away because they don't feel that buyers are getting that buyers understand and that buyers are getting the representation that they need. I'll find it. I'll send it to you and for another day.
Yeah.
That conversation.
I'd be interested.
Is it based on the fact that the buyer agent is being paid by the seller?
Something about that, yeah.
Probably, yeah.
Yep. And so
I mean, there is a lot going on,
yeah,
you know, in that regard. And, you know, our MLS just recently made the field of buyer, the offering of cooperating compensation is now a field that is viewable by the public, where it was not before. And that was just in May or June, I believe. So now the buyers, when they're perusing properties that are on our MLS, can see what's being offered out to buyer agents. You know, they see that field. So, okay, there's a question in the chat. Address agency on this scenario, eliminating dual agency. I'm not sure if I'm not sure if what they mean is what Catherine was referring to, whereby if you are working with an unrepresented buyer and you're answering all of their questions and whatnot, you could be in an undisclosed dual agency situation by your actions. I'm not sure if that's what they mean, or Jill, maybe you can elaborate on your question. Or is she meaning that, you know, when you're a seller agent, and you have an unrepresented buyer, your agency disclosure would still be as a seller's agent? Not sure if that's, you know, what she's meaning. But we'll see if we get more information on that. I mean, agency is like a full day conversation, right? Anyway, and even then you still have questions.
Well, I'm wondering if the question is, you have a listing, you have the exclusive of marketing agreement with your seller, you have the fiduciary duty with the seller, the unrepresented buyer comes and you want to dual agent, you have to go back to your seller, and it becomes a awkward scenario. I'm wondering if that's where Jill was going with it. Also, Catherine, where would a facilitator fill in that spot? And is that a solution to an otherwise troubling, awkward relationship?
So if you are already in an agency relationship, you can't back up and go to facilitator, because even though facilitator is on the agency disclosure, it's really the consumer licensee relationship disclosure, and a facilitator is a non-agency relationship. You don't represent either party in the transaction. So where you represent one party, you can't downgrade that agency relationship, and you can't act as a facilitator with the other person. If you're already in an agency relationship, your options are to continue in your single agency relationship with whichever client you have, or to enter into dual agency at that point. And obviously, if you're entering into dual agency, you need that consent and notice given to all parties in order to proceed. Same with designated. You need to have notice and consent as well for designated agency. And I think Jill is elaborating a little bit more. Let's see what she says.
So I think she's saying in the first paragraph that eliminating dual agency by disclosing to the buyer that you're a seller's agent. So that buyer's unrepresented. And then she says, as representing the seller with an offering, of course, to allow. Not sure about the last sentence.
The thing is that dual agency is, as much as we, it's a legal option, who does it benefit? You've made a promise to the seller to say, I'm going to put you highest and best, you're my fiduciary duty. And then basically halfway through the thing, it's like, well, I'm going to have two masters now. So I'm going to do my highest and best. So you become like, you do become a facilitator. It's like, okay, you want to offer this price, seller, do you like that? Nope, you're not willing. Okay, do you like that? I mean, you become this middleman, because you can't be saying, oh, you'll take this, but negotiate that. Oh, okay, you'll really take this, but like, how do you serve two masters? Now I understand it's legal, but it's just, I don't see the point of it, because you're not really doing your highest and best for either client. I know the money's great, guys. I'm not shirking anything on that, but when it really comes down to it, I do feel that I could potentially see how either party could eventually have a claim against the agent saying, did you really get me the highest and best, or did you really get me the best price that the seller was willing to go for? Because you probably can't do both.
I'm a big fan myself of referring buyers to, on a listing, unrepresented buyers. I'm a big fan of referring them to someone in my office that can represent them. Because I think what Catherine had said in the beginning is, that's a way where you can have a smooth transaction and each party has their professional representation, and you don't have to be in that sticky situation that you're describing, Carla, or constantly. I mean, I have not had that situation very often at all, but in one that I did, I think that I counted, there were 50 emails where I said, to these buyers who insisted that they did not want representation. And Catherine, you said you can't force them. But there were 50 emails where I said, remember, I don't represent you, so I can't answer that. Remember, I don't represent you, so you have to get that answer somewhere else. And it was awful. I mean, they should have had an agent, but they didn't want one.
Well, and I think the misconception is two things, because I have friends who are like, oh no, I'm going to go straight to the listing agent. They think they're going to somehow get the inside scoop somehow.
Right.
And they think that because they don't have an agent, that their offer might be given preferential treatment. Now, if you look at it from a money standpoint, would the agent potentially look at it that way? Yeah, but it's not from the selling standpoint. If the seller doesn't have the agreement that maybe there's going to be less of a commission if there's a dual agency situation or something like that, it doesn't actually benefit the seller in any way to take a direct buyer without representation. And so I don't know where this fallacy is that the buyer is somehow going to win by not having representation, but it's definitely a held belief by a certain swath of the population.
And I think to the original, question, and Catherine went over some of this, but you know, because you have an agency disclosure does not mean that you're procuring cause. I mean, I think I see this a lot. I mean, it's one piece of a puzzle, but if you have an agency disclosure with a consumer, and it's as a buyer agent, it doesn't mean that wherever those buyers go and whatever they look at and whatever happens after that, it does not mean that you are entitled to compensation, because there's a lot of pieces that go in to procuring cause, and it can get pretty complicated.
Nor does it mean just because they're on your MLS daily emails that
Right.
you're procuring cause. Nor does it
Right.
mean if you had, as a buyer, had gone to an open house and signed in with your own name, regardless of how many times the agents say don't do that, and the listing agent calls you and says, hey, I have another open house, would you like to join? That agent is necessarily procuring cause. Like one movement does not make procuring cause.
Right. Yeah, it's the sum parts. You know, and to that point, you know, a lot of times we see these listings where it says agent must accompany buyer on their first visit. You know where I'm going with this. So what do you have to say about that, Catherine?
So I think it depends on MLS or non-MLS listings. If it's in the MLS rule is that you make an unconditional offer of cooperation to the broker who is the procuring cause of the buyer. You don't get to define what procuring cause is yourself. Procuring cause is determined by the MLS rules or by the arbitration panel if it ultimately goes to that. You can't make up your own rules. Obviously, if you have a situation where you've got a buyer's agent who is not present for critical points during the transaction, it may raise a question of procuring cause. If they're not there at the showings, if they're not there at the home inspection, they're not there at the final walkthrough, well, were they really a participant in the transaction? Did they create that unbroken chain of events? So I see why people put that in there. But in accordance with the MLS rules, I think that's placing a condition on it outside of what the MLS would allow. If it's a non-MLS listing, terms of compensation are negotiable and through agreement. So absolutely, somebody could say, I will pay you blank amount to represent a buyer. However, you must be at all of these critical events in order to obtain that compensation. So it depends on where that property is located or listed.
If you have a non-MLS listing and there's just an open house, because I think most of the time what they're getting to, yes, of course, if it's a private showing or anything else like that, that makes complete sense. But open houses, and we all know, you know, especially on a Sunday where it could be a religious day, you know, open houses are from 11 to 2, maybe 11 to 4, you know, like, but they all end up being in the same almost like 2 to 3 hour time frame. So a lot of agents will say, oh, yep, you know, go to the open house, you know, sort of thing. But if it's a non-MLS listing, how would you know what the terms were until you've already been to the open house, where it would be potentially too late to know that they said, oh, well, if you aren't there on the first showing, I'm not willing to compensate you. So
right. Yeah. I mean, there's lots of factors that can go into it. I mean, so if it's a non-MLS listing and it's advertised on social media, for example, they could include that there. But yeah, you might not see that. And then it's that agent's obligation who's representing the buyer to either negotiate directly with the listing broker to see if they can enter into an agreement regarding their compensation, or seek that compensation directly from their client. You know, because in a non-MLS situation, there's no obligation to compensate a cooperating broker ever. So, you know, it's really all a matter of agreement.
Okay, so this was question that came, or a couple of questions about this that came in with people registering, and there were some on our last webinar that about the same thing that we didn't get to. And this was revolving around specifically around appraisals, language for gaps in appraisals. Also, a lot of questions about the amendatory clause. So, you know,
Mandatory clause?
FHA, a mandatory clause, sorry, VA, you know, if there's an agreement between the buyer and the seller, and there's, you know, the buyer has agreed to make up an appraisal gap, and then, but then you have this amendatory clause, like how does that all fit in? There was like probably 6 or 8 questions, all revolving around appraisals and then the amendatory clause. And what kind of language do you suggest, you know, to be on the lookout for if you're a seller agent? What can you use if you're a buyer agent? So if you could.
I'll start on this one. This is kind of becoming a nightmare on deals. First of all, with the mandatory, I've had a couple deals where the VA or FHA and the buyer had agreed that they would pay the difference between the price and the appraised value. And so we had to, in the contract, that the mandatory clause would be signed, but it's superseded by this contract and the appraisal acknowledgement by the buyer. But the reality is most people in that bracket for a loan don't have the money to make up the difference. So that's why you see a lot of complaints about FHA and VA buyers in this market not getting deals. One, just because of these mandatory clauses, limited ability to make up differences and gaps on appraisals, and also the inspection requirements that these lenders have, termite inspection, pest inspection, what have you. In terms of the appraisal language, so you have that bucket, you know, then you have kind of like the 5 to 20% down. With, I'm a big believer, because you can argue the same way you want. In the additional comments, brokers, back when the market was more normal, would put in buyer's obligation to perform is contingent on the lender's appraisal, valuing the property at or above the price. Okay, so if people put that in, obviously that's not implicit in the mortgage commitment just because you're getting a mortgage. If somebody's putting 20% down, 30% down, 40% down, they're putting that in there because they want to have that contingency. In this market, if you were to put that in, if you're in a competitive market, if you were to put that in, the additional comments in your offer, you're not going to get the deal in most places. They're not going to take your deal. You take it from somebody else. So when we get to purchase and sale, what a good seller's attorney should do is put in that buyer acknowledges their obligation to perform is not contingent on the appraised value of the property. And any such condition in the mortgage commitment, if there is a mortgage commitment, shall not be a valid reason to cancel. But then that's when the arguments start, because then it gets, well, we never said that we were waiving our rights, that we agreed to pay the difference. But if you've got 30, 40, 50% down, you've got the funds to make up the difference. And if you, and again, I kind of backdooring this argument, if you're trying to put in an implicit appraisal contingency, and it becomes very problematic. So my advice is, if it's less than 20% down, chances are people don't have the funds to make up the difference. You just have to go along that if you're in a situation where that was the best offer you got from financing, you took it. If it doesn't appraise, they probably can't get a loan. If it's 20% down or more, I would advise, if your seller really wants to be clear, and they do hold the cards in this, is to just put it in there that buyer's obligation to perform is not contingent on the appraised value of the premises. And that will either get accepted or it will cause a negotiation where, let's just say the property was listed for $1 million and it went for 1.1. You might get the buyer to say, fine, if it appraises at $1 million or above, I'll take the property. But you got to deal with it. I think to just bury your head in sand and say the attorneys will deal with it when it comes about. I had one yesterday. It was a nightmare. I literally had one yesterday where the property was listed for 1.675. It went for 1.7. The offer said buyer would purchase the property if it appraised at 1.675 or higher. I got the draft from the seller's attorney, and it said that if the property appraises at 1.675 or lower, the buyer shall buy. And I'm like, that's not what it says. And said, well, that's not what the seller understood. I'm like, but that's not what it says. Well, that's not what the seller understood. It was like 5 hours of mind-numbing, banging my head against the wall. And we finally got them to say, okay, that is actually what the language says. So very, very toxic part of deals right now. Clients that are buyers have to understand that if they're signing it and there is that language that's inserted, that if the appraised value is low and the language that says they've warranted that they have the money to make up the difference, they can't get out of the deal if the appraisal comes in below the price unless they're willing to lose their deposit. So a lot there, I'm sorry, but I've just been dealing with it so much, I'm ready to.
Oh, it's a four-letter word. I mean, I think all of us attorneys can agree that appraisal right now is a four-letter word.
I just think the age, no offense, agents, I just think a lot of people are like, I think there's a lot of misinformation, even in the lender set. And I think there's a lot, I had one last week where the buyer's like, well, of course I have a mortgage, so of course it's got to appraise. I'm like, no, you're putting 40% down. If it's 10,000 off, you've definitely got $10,000 to make up the difference. And you didn't put an appraisal contingency. So that's how this deal is going to roll.
I think it comes down to the meeting of the minds, right? We talked about this earlier. We have a contract with the offer. The offer is a contract. And if both parties don't understand it, then it needs to be written a little bit more clear, right? So what is the best foot that the buyer is bringing forward? What is the buyer willing to do? It comes back to the disclosures that we talked about, the half truths. Why would you put a partial disclosure or step away from that hard conversation? Yes, it's a hard conversation. Yes, I understand the appraisal is not going to come in. This is what I'm willing to do. This is the best foot forward that I'm presenting. Is it clear to everybody so that the attorneys aren't fighting over this, because it's not supposed to be renegotiated at purchase and sale agreement. It's supposed to carry through the mirror language, but the language has to be clear, unfortunately. And the parties.
And on that, and I mean, talk to your lenders, and I was a lender way back. If you put down, if you have cash, the bank is looking at the lower of the price of the appraised value. So they're not going to, unless you're VA or FHA, USDA loan, unless you're that, they're not going to de facto deny you because the appraised value is less. It's, do you have the assets to make up the difference? And I don't think a lot of agents and even lenders understand that if it's not just the appraisal was $1,000 less, but I get $3 million in the bank, oh, I don't have to buy it. It doesn't work that way. And you got to realize that if your client is very sensitive to not wanting to pay with the bank, in their opinion, the price of the value or the value of the property, happens to be on that particular day, if they don't want to pay the purchase price if the appraised value is less, then you probably should be very clear in the offer and you might not get the home and you make yourself uncompetitive.
And you have to be clear, and the reason is for agents to understand is this is when you go to the lender and say, will you issue a denial letter if this property appraises $10,000 under? Because what Brad is saying is if they have the money, the lender doesn't have the right to deny it because they still qualify for the loan. So if the exact language is must appraise or must appraise at a certain amount is not in there and the buyer can't get a denial letter, then if buyer doesn't want to buy, buyer loses their deposit. So I think you really, as a listing agent, need to be, and I love the term, the parent in the room, that when you get an offer, you maybe rewrite whatever you think is in there to exactly what your seller is expecting to happen. You write back, property appraisal is not going to be an issue, whatever, or property is not subject to appraisal. And then if the buyer comes back and goes, no, that's not what we meant, you're working through this now. Or if they, and I said this last time, the minute we start going over asking, the appraisal conversation needs to be had. Just because it's not being had doesn't mean that someone doesn't need to be having it. Because exactly what are the expectations? Because as I've told people before, if it has to appraise, then why not offer $100,000 on a $300,000 house over asking? Because if you know that you can still get it for $300,000 instead of paying $400,000, then we're just playing with funny money here. So the minute specifically it goes over asking, we need to be having that conversation. What is the seller's expectation? And if there is some sort of quasi appraisal language in there that you don't maybe understand, then that needs to be rewritten before the offer is actually signed and accepted. There is the seller. I feel like sometimes the listing agents forget that they can counter offers other than just, purchase price or closing date. There are a lot of other terms in there that you can work through and make it just simple fall off the wagon language, plain English. Us attorneys will turn it into whatever we do with our magic words, but make it super simple that anyone reading it knows, yep, this is exactly what the parties were intending to agree with. And I know I said it last time, when you send over the offer, send the attorneys the pre-approval. The pre-approval is part of the package. If the pre-approval states it's subject to the property appraising and the offer is otherwise completely silent to what's going on, then the attorneys could say, okay, well, you read the entire offer. It didn't say anything about appraisal, yes or no, but you did read the pre-approval and it says it's subject to appraisal. So I would argue as a buyer side that you looked at the entire package. You looked at my buyer was qualified. You did not waive your appraisal, and the listing side didn't ask you to waive your appraisal. So therefore, the pre-approval shows that the appraisal was part of the offer. And at least I'd have an argument to jump from. And now, will I win or not? Who knows? But again, that pre-approval help. Same with like if it's an FHA or VA. I don't know what sort of loan you're getting, so I might want to talk about that. Same with if there's closing cost credit. And now we got FHA or VA. Is anyone talking about, will the closing cost credit be reduced if the seller has to do work? You know, like these are things that should probably be talked about again up front before we have the situation. And then everyone's going, well, I'm not giving them $10,000 closing cost credit if I'm doing $2,500 to the house and paint and, you know, scraping paint or something. And then we're back into trying to renegotiate. And now does the buyer actually qualify? Because if they thought they were getting $10,000 in closing cost credits and they don't have this $2,500, did the deal just fall apart 3 weeks into it?
And on that point, though, I think that's what makes a really good listing agent in this market is, and I've got one referral source who's excellent at this, is when she's controlling deals and she's got multiple offers, and again, it's got to fall into the bucket where it's not a government loan, what have you, but she always will write in this market that buyer acknowledges that their obligation to perform is not contingent on the appraisal. And it just, and sometimes the answer is, well, no, that's not what we understood, but at least a negotiation happens. Then oftentimes, if we're going over list, the appraisal language is that the property has to appraise at the list price or something like that. But at least there's some type of meeting the minds Mark spoke to at that time. And that's extremely important. Again, we're not trying to not do a job and not work, but at the same time, business terms are supposed to be agreed to, and it's not our job to negotiate them. And it causes, I think, once everybody gets the offer signed, and a lot of buyers and sellers like, oh, the purchase and sale just has to be done. And then all of a sudden this major contingencies coming up after they thought they had a contract signed, and they did. It doesn't help for the relationship between buyer and seller, and there's still a long way to go.
So it sounds like you're all, at least for right now, saying that in the contract to purchase, the offer, that don't stay silent on that subject.
If that's what your client wants. Yeah, on both sides. You just got to know your client. And you gotta be realistic too. Like if it's FHA, it's gonna be very hard to push that, but some people do have the money.
Well, to the FHA, I think that, you know, some of the questions were revolving around the buyer and seller agreeing to something concerning the appraisal, and then the amendatory clause says something different.
Well, you can have, I had one, you can have the amendatory clause just change. I had this lender do it. It basically, the agreement was, it was lower than the price, and that was in the contract, and the lender changed the mandatory clause to list that number that we had because it was in the contract, because it was agreed to. And I don't know if that's, I don't know the ins and outs of VA loans by any means.
I also know it's been an issue with buyers entering into an agreement, possibly going one way with a loan, and then, you know, now they've offered over the asking or whatever, you know, something has changed. And so switching after the contract is signed, switching their financing to FHA. And now all of a sudden, you know, this mandatory clause appears when you didn't even know that the buyer was planning to get an FHA loan.
Well, then you run into issues though. You run into issues on that with how the mortgage contingency clause was written, and you were supposed to apply for a loan within 3 business days of receiving the agreement. You have a mortgage commitment date. I mean, if you've gone from conventional for whatever reason to FHA, you're gonna have to notify the seller's parties that you can't get financing and ask for an extension because you've got to now go for a different loan type and what have you. But if you were to try to say, oh, I can't, to just midstream switch because you didn't get denied on the first one, I'd argue that you're violating the mortgage contingency clause because you didn't apply for that loan within the time frame called for in the purchase and sale, and you might run into some issues there.
What if you didn't though? This happened just recently. They applied for this loan and they found out they could get a much better, with a different lender. So they did comply, but that lender couldn't give them a denial letter. But then they switched horses halfway through, and then of course we needed extensions, and it became this whole mess because they complied, but now they needed extensions, and the seller didn't want to give them for very good reasons, because they weren't even going to have their appraisal back until after the closing date. They needed 3 weeks. So yeah, it becomes a mess, and it does. And then you have to have a second appraisal because now you didn't have the VA or the FHA appraisal. So you're having a second appraisal, you need access again, new requirements, potentially a longer closing time. And yeah, all the other things that, Brad brought up. So it's, there's sometimes that there's a reason, like I had a closing just on Monday that the lender gave a huge MIP credit. And so it ended up being a better loan because they didn't pay the mortgage insurance. And so it just ended up working out in their favor that they did FHA instead of conventional.
Well, I have seen, and I know that others have told me this as well, these very scant pre-approvals that aren't giving you much information, including what type of loan, they're getting. And then you've got to ask and, reach out to the lender and get that in, because, obviously certain properties that you list, you're pretty confident that there will be issues with an FHA or a VA appraisal because of the condition, the peeling paint or the, missing rails, or, the garage had termites or, whatever. So you're trying to be mindful of those things, but buyers are coming in with these pre-approvals that are short on information, I guess I would say.
Yeah, and then on that, this is a little bit of a digression, but you got to be very careful with your clients, with national lenders who don't understand the ins and outs of the state they happen to be lending on in this case.
Yeah.
And we have time is of the essence in Massachusetts. So if you're supposed to be closing August 16th, it's August 16th, and you could actually argue whatever the time that's listed in there, noon, that's when it's closing. And I had somebody, a lender out of New Jersey, and I had one, I think Michigan, and like, oh, we have a floating closing date, right? I'm like, absolutely not. Like, we're going to lose the deposit if you guys don't perform. So on that, you get these scant pre-approval letters, but then you just got, in this competitive market, it's again, consumer warning here, just make sure the lenders, and this is blocking and tackling every job, but make sure the lenders can perform and they know what they're doing. Because it's just that sellers don't care. Like, they'll just walk away with the deposit. They can go get somebody else to buy the house. It's not a problem.
Good advice. Our next question is about what are you seeing as far as people, both sides, buyers and sellers, and listing agents and buyer agents wanting to get out of contracts. So I think, Catherine, you had something to say, first of all, about a representation contract. So maybe you could start off by talking about that. And then I know these guys are probably dealing with all the rest of it on a daily basis.
Yes. So, on the hotline, definitely have been getting more questions from our members about clients. Usually it's an exclusive right to sell listing agreement where, for whatever reason, the seller wants to list with a different office. And I get a call from usually it's from this, subsequent broker, sometimes from the one who, doesn't want to release the client from the contract, saying, somebody called me and they've got a listing agreement, with Mark, but they want to list with me. What can I do? The first thing I always tell them is nothing, because both from a legal perspective as well as from a code of ethics perspective, you cannot be interfering with another realtor's exclusive right to represent a client. So if somebody gives you that call, the only thing you should say to them is, well, since you're under an exclusive agreement, I can't work with you, but I'm happy to speak with you once that agreement has expired or terminated, or whatever phrase you want to use. So that's the best way you can protect yourself in that situation. If you're in a situation where you have a client who approaches you and says, listen, I don't really think this is a good fit, or whatever the situation is, I'd like to get out of our agreement. I know it goes, until September 30th, but I'd like to get out of it today. How do you handle that situation? And this is where I tell people the legal answer and the business answer probably aren't the same. So from a legal answer, sure, you can enforce that contract, and then you're stuck working with a client who doesn't want to work with you. And what is that going to do to your reputation as a self-employed individual? Your reputation is what's important for you to be able to make your livelihood. So that's where there's a little bit of a conflict there. But from a legal perspective, you can enforce the terms of that contract until the date set forth in that contract. Whether it's a good idea to do that is another decision to be made. And again, if you're a salesperson, that's a conversation that you need to be having with your broker, because ultimately they're the one who controls that, not you as a salesperson.
And on that note, though, you guys have to realize, agents or brokers, that if your seller is now like, you can't come to my house, I won't allow any showings, I will not let you have an open house, I want to fill out a form that you take it off MLS. Like, the question becomes like, what's the point? Because your listing agreement probably states anyone that you've already introduced to the house is, you're going to get paid on whatever for the next 90, 180, whatever it is, days. So if the client is, I think the first conversation is why, what is it? Did you find someone who will list it for less? Do you think I'm not doing my job? How long was the contract for to begin with? I mean, not for nothing right now to have, a 6-month, 9-month, year contract. If you haven't gotten the job done in 3 months, with rare exception, I found a client called me the other day. He signed a 2-year contract, 2 years. Why? He wanted out of it. I was like, well, what has your agent done for you so far? And then there's that conversation. But the question, I think the first thing is to have an open and honest conversation of, why do you want out? What's going on? Especially if this comes as a shock to you. Not that you've already had some, disagreements or anything. But they're probably not going to let you do your job. So, what's the point?
Are you all seeing, what about buyers and sellers who, a buyer decides they don't want to buy, or a seller decides they don't want to sell? What are you seeing out in the field?
I think the seller one is the seller's remorse of, I can now get more money. So I've had it happen a couple of times that, buyers ask for like a 2-day commitment extension. And sellers have been like, nope, we're going back to market, I can get more money. And, then the buyer's side is yelling at me stating, you guys aren't negotiating good faith. This is unreasonable. We had a tight timeline. You knew this might be a possibility. And I'm like,
time is of the essence.
It's my seller's right. Do I think it's good business practice? No, but it kind of goes back to in the beginning when someone said you were talking with an agency. I was told by an agent not too long ago that her coach had told her single extension that's requested has to be granted. I was like, I don't know where you got that information. No extension has to be granted. So I had a deal actually fall apart yesterday. They said, if your commitment is not in our hands at 5 o'clock. And she was like, well, my loan officer said maybe by 6. And I was like, 5 o'clock is the time. No one's budging on that. It is 5 o'clock. If I do not have it, deal's over. We're cutting check, returning it to you, period, end of story. So, sellers, that's the number one reason that I'm finding is that sellers feel like they can get more money and they're willing to roll the dice to get another 10, 20, 30 grand out of a house that they think that they can get it on.
Oh,
Buyers, I think it's a completely different story, you know, the why comes in, you know, and then was it the informational purposes only inspection, and what did that mean? And again, the meeting of the minds, what did that really mean, you know? So I think it depends why the buyers want out. The sellers, I'm just finding it's for money, or they can't, or it's a little bit different if we've already signed PNS or something like that and they haven't been able to find a house. That's why they're getting out of it, is that, you know, there was some sort of contingency that they had to find housing by a certain date. And then the question is, how was it written? Is that, you know, was it a unilateral decision or a mutual decision? Because sometimes it's the buyer solely has the right to choose if they want to extend or not and give the seller more time, or sometimes it's the seller has the right to say, if by a certain date I haven't found a house, I have the right to cancel the contract. And again, most people are like, let's just get this signed, and then you want to rely on a paragraph, and it's like, well, why was it written this way? Well, we probably should have had a bigger conversation about it, but everyone was running to the finish line for it.
And again, this comes back to buyers understanding the risks associated in this market, you know, that they're clearly understanding what they're going into. We're seeing some folks with silent sale contingencies, right? So they have a home to sell, but they're not putting that forth, as Brad would say, because their deal would be rejected, right? Their offer would be rejected. So they understand the risk. And now we have a scenario where that buyer of the house that was being sold that was not written into the agreement is falling through. And, you know, seller says, well, what do I do with this buyer's deposit? You know, can I go back on the market again? You know, they're terminating, right? They put in a written termination. What can I do? How do I handle this? Can I go back on the market? Can they tie up my property with a Liz Pendants? And you know, we hear this over and over again, where the buyers use their leverage as, well, we're going to go into court and you're not going to be able to sell the property. And that's not true. That's just factually inaccurate. So want to encourage people to not, you know, fall to that, because it becomes a monetary dispute at that point over the deposit, right? So the property agreement has been terminated. The buyer says, you know what, I can't do it. The mortgage contingency is coming up. I know I didn't tell you about this house that I'm selling. Now that you know about it, here's what's going on. I want to terminate, right? Or it's just after the commitment, even worse, right? So what happens? Well, seller, you've in effect been taken out of your agreement with this buyer. So put it back on the market in this marketplace. Hurry up, and then let the chips fall where they may with respect to the deposit, how you want to handle that with the, you know, lack of transparency and all of that. Or when that new buyer comes in, you release it. But to be of the misinformation that you're held hostage to that person is I just want to stress is factually inaccurate.
That's a great point, Mark. I get that question all the time. And the answer is different too, which I think is important to point out, that it's pretty important to note who's the one who's walking away from the deal, because if it's the seller who's backed out, they need to be talking to their attorney about putting that house back on the market, because then the potential for litigation and a Liz Pendants is probably increased. And if you get a buyer who backs out, don't take it on a phone call. You get that in writing before you take any action, just because that's going to help protect you from any potential liability. If you get a call from the buyer broker that says, hey, my client probably isn't going to make their contingency date for financing, we're gonna back out. That's a little too uncertain, willy-nilly. Don't rely on that. Say, all right, well, give us written notice as required in the contract by whatever date and time, and we're happy to release you from the contract. And then you have something in writing to verify that you're acting appropriately.
And I think that is deposit dispute, Catherine, that's what I was going to say. It depends on who is breaking the contract. If the seller's breaking it, the whole Liz Pendants thing, if the buyer wants to buy, the buyer would have the right of a Liz Pendants. If the buyer says, I don't want to buy, completely different story. But I think something that I oftentimes, if it's not too long of a date, is agents need to remember that even if the buyers didn't get their mortgage commitment and you're not willing to give their money back, who knows that mom, dad, aunt, grandma, or something is going to be like, here's a check. So if you're going to put it back on the market, you do not, first of all, I mean, I think that, in my buyer's addendum, it says there's no pending litigation that the seller knows about. Well, there could very well be pending litigation coming up if there's a large deposit at risk. So one, you better make sure that that's not in the rider or that you're representing it correctly. And then two, you probably shouldn't sell that property until the original closing date of the buyer that has now walked away has passed. Because if you go and sell it and buyer goes, grandma gave me money, I'm at the registry of deeds, where's my deed? That's again where we end up with, a huge title issue because you went and sold it to someone else, So once one party wants to step away, that is absolutely when an attorney needs to be called and you need to be advised correctly as to who has the right and what should be done. Because the fallacy always is that if the deposit isn't being released, you can't put it back on the market. And that is an incorrect statement. It's on the who and everything else like that.
Have you, how many times have you had to show up at the registry when no parties are there?
Chris Crowninshield does that like once a month.
You make him go do that?
I make him go. He's really good at it. I just want it stamped.
There's a great process set up for that default scenario. You go to the registry and have them paged at the time and place, as Brad was talking about in the purchase and sale agreement. Time is of the essence. You're there, they're paged, they sign a book. It's evidence for that matter. Now, that brings the buyer side of it, right? Seller gets cold feet, wants to either not sell or sell to a higher bidder. You have the action for specific performance. It's a unique asset, right? You cannot buy that house in that location anywhere else. So the buyer has the absolute ability to litigate that issue, and it's called an action for specific performance. And that's Exhibit A is you were there, ready, willing, and able to buy.
If you do that, and on those points, I mean, if someone on either side isn't performing and you do go show up, it's amazing how much that can speed up at least some type of agreement between the parties. That, because I've had some where they just don't do anything. It's like, well, I had the deed. I'm like, I don't care. Like, you had the deed, like, we didn't think we were performing. But if you actually take the step, the attorney takes the step to go on either side, and particularly on the seller side, and have the paging done, have the deed stamped, show up and be like, listen, we're enforcing this. And to take a step back, and I think it's implicit, but just because the way our contracts are written for the most part on a mortgage contingency, just because you don't get your loan doesn't mean the deal's over. It just means that you don't have the contingency anymore. So unless you say I'm terminating because I couldn't get my loan, and then maybe there's a dispute around that, you can still, if your buyer wants to take that risk, if their loan, if in this market, if their lender didn't have the commitment by, like Carlos said, by 5, and the buyer's like, you know what, all they needed was a 4506. I know they're going to have it next week. I'm fine. They're not going to give us an extension. I'm buying this house. So the seller's got to understand, and I get this question all the time, and agents do it, and it kind of frustrates me. Where's the commitment letter? I'm like, we don't have to show you the commitment letter. It's up to us to just cancel. We can be silent. Like, we let it go by. We'll see you at closing. We don't have to show you anything. So you got to understand the nuances in our language, and that there's not an affirmative action on the buyer to show something that they have a commitment if they're just going forward. There is an affirmative action if they're trying to get out of the deal. If it's written how you write, I write my seller side contracts, that you've got to show some written correspondence from the lender that we can't give a commitment or there's a denial. But just know the differences between those, and don't just assume because your client maybe has a couple of things left on their loan commitment and the lender's not able to get it in time by the mortgage commitment and the seller's not willing to extend it. Doesn't mean the deal's dead. It's just, is your buyer willing to take some risk?
And that's a big, and that's another fallacy that's out there, that the selling side is entitled to a copy of the commitment or, anything else like that. And anytime an attorney writes that in there, that, here's the date and we are entitled to copy the, I cross all that out. I'm like, no, you actually are not. Every once in a while, I'll make an exception for a redacted commitment if the seller's buying and they're, someone on their other side required to see that because it's a domino situation, sort of thing. I may be willing to agree to a certain amount of it, but as for, across the board rule. No, it's the buyer's money that's at risk. So it's the buyer's right to just let that day pass and roll the dice and, you know, do whatever they want. So as Brad said, it's not an affirmative action that they have to take. That day comes, it goes. And that's why, honestly, listing agents, you're doing your seller a disservice by asking the day before, the day of.
I agree. Be silent.
Be
I
silent.
agree.
The day after, because you know what? If someone forgot and they're like, oh no, you could have just cost your seller the deposit. It's the day after the commitment date. You can write, hey, by the way, did the buyer get the commitment? You can ask that. Don't remind them ahead of time. You're not doing your highest and best for your client by asking. I know that you think that, because of course the seller wants to sell. The seller doesn't want a deposit, the seller wants to sell. So of course everyone's anxious to find out, are you qualified? But wait that 24 hours, then ask.
Well, I think if you go back, you know, to the dark ages, you know, we as sellers agents used to get the commitment sent to us right from the lender, right? Years back, that's how it was done. So a lot of people that have been in the business for a long time were accustomed to automatically getting that commitment, and you know, it was hard for some people to make that change, you know, but as a lot of us operated as sub-agents of, you know, of the seller back in those days, of the sub-agent of the seller's agent. So things were a lot different, and there were a lot of adjustments that had to be made. So during that kind of changeover, you still, if you were a buyer agent, often would have the listing agent asking you, where's your commitment? Where's your commitment? And if you were the one to say, well, you're not entitled to that, you know, it was kind of difficult to get around that. But I definitely hear what you're saying, and it makes total sense. Jill is making a comment, basically just that buyer agents need to reinforce that, you know, these offers or contracts to purchase are actually contracts, and that you need to let your clients know that they are signing something that is enforceable.
Do you think most agents know that?
Know that the contract to
That an
purchase.
offer, because of McCarthy v. Tobin, can go to closing
I
without a
mean,
P&S?
You're
no.
going to lend on it becomes the problem. It's like, you're right.
Can you get access to do an appraisal and stuff
Right.
like that?
So if
Right.
it's a cash deal, 100%.
But if it's cash, yeah.
So, but if
Right.
it's, because that's the argument, you're absolutely right. That contract, we can rely on it 100% of the time. We don't need a P&S. But it does state in there that we're going to sign a Greater Boston or MAR or significant, you know, relatively significant on or before a certain date. So if that P&S isn't signed, then the question is there a breach, and then you're entitled to the $1,000, the $500.
Well, no, but then you got, but then you get McCarthy v. Tobin. So if you're doing a loan, it's impossible. Good luck getting in the house unless you can do a drive-by. But if you get cash, there's precedents where you can take an offer all the way to closing. So my thing is like, just sometimes you hear where it's not a free look. It's $1,000 though, right? So at the end of the day, I think some people are willing to risk it, what have you. But I just sometimes hearing from the clients, like, oh, that if we don't come to an agreement here, they can still move forward. I'm like, yeah, there's legal precedents that they can. It's hard to do, but it can be done.
No, I think that we as agents could probably do a better job, you know, letting the consumers know that is a contract that they're signing and they're putting their name to, and that they're promising to do these things that are written in there. I was in a class once where there was an agent in the class who said that she tells her buyers to, you know, go ahead and, you know, put this offer in, and you know, what the heck, all that's going to happen is you'll lose $1,000. So in other words, she was waiving the you know, certain things and then telling them, well, you'll do it anyway, and if you walk away, you're just losing $1,000. And you know, everybody was kind of like, what?
Yeah.
And that was in a class, you know. So yeah, I mean, people operate different ways, but definitely I think we could do a better job.
And I had two questions. I made a note of this. I've had two questions this past weekend. to me. Is it legal for my buyers to put in offers on multiple properties at the same time?
Oh,
That brings you to that, because agents are like, well, what's the worst that could happen? You'll lose $1,000. And I was like, well, first, you're not negotiating good faith to multiple parties. And technically, you're not supposed to be putting in an offer for more than what you're qualified for. So if you're trying to buy 2 houses each for $500,000 and you're pre-approved for $1 million, go for it. If you're putting in 2 or 3 offers and you're only pre-approved for $500,000 and all the houses are $500,000, you're what you're doing is you're actually lying in a contract because you're not qualified if all 3 of them were accepted. So that's something that I've heard little conjecture over the last 6 months that people are doing. It's like, well, we need to increase our odds of having an offer accepted. So
right.
2 or 3 houses, we're going to put in 2 or 3 offers. What's the likelihood we'll get accepted for more than one? I don't know how many agents find that that's an ethical way to do business, but I do know it's out there in certain pockets.
Well, people
I've
get
heard that
desperate.
Yeah, I've heard that as well. And, it also raises the question that I touched on a little bit before too, is there's the legal analysis, but you also have to think about the business analysis. If you start having a reputation out there that for every buyer client you represent, you put in 3 offers and then you either rescind 2 before they're accepted once you receive acceptance, or then you just back out. And how does that harm your business reputation? And, you all work in relatively small communities where, your peers that you're working with, and that can influence, future transactions. It might be okay for one client, but how is that going? What's that domino effect going to be for your future clients? And are you going to be able to fulfill your fiduciary duties to them when you've got a crummy business reputation where Mary is saying, I don't want to work with Catherine, Catherine's client submitted an offer on this. You don't want to accept that because they're probably going to pull it back anyways. That's hurting my future clients, even though it might be benefiting one. So there's a lot of layers to analyze with that. I don't think it's a good practice. I wouldn't recommend doing it. And if you've got a buyer who's considering doing that and is, pushing on it, send them to their attorney to talk about it, because, that you don't want to be in a position where you're giving legal advice. And that's really a legal question of, what risks are they potentially facing?
Catherine, on the inverse of that, in this scarce marketplace, you may have a buyer agent that has 2 clients looking to bid on the same property. How do you advise that buyer agent?
That's a tricky situation. So technically, from a legal standpoint, there's nothing illegal about representing both of those buyers. It's not dual agency. You're not acting as a dual agent because you're representing 2 buyers. However, you have to do a little, introspective analysis and determine whether you're able to fulfill your full fiduciaries to both of those buyer clients. You also have to be very careful to not use any of the confidential information of either of those buyers. You submit an offer from buyer A for $300,000. Buyer B says, I want that same house. What do I have to do to get it? I need this house. You can't say, oh, well, I know there's another offer on the table for 300. So you got to at least beat those terms, because then you're in breach of your duties to buyer A. You can, I think it's very difficult to separate yourself in that situation. I think it's probably from a risk management standpoint, the safest bet in that situation is to try to refer one of those buyer clients to somebody else and say, listen, this is something. And I think people respect that also. If you say, I want to make sure that you have the best representation possible. And in this situation, I don't think I can do that because there's a potential conflict here. I think people have a lot of respect for that. So, you can do it. And I will say, if you use the MAR exclusive buyer representation agreement, there is a line in there that specifically addresses this situation that says, this may arise. I may represent more than one buyer submitting offers on a property. That's not a conflict. I'm able to do it. So if you're using our contract, there's nothing illegal about doing it, but I think there are potential risks associated with it.
Definitely. That's a sticky one. There were a few questions about solar panels, and mostly they were revolving around, suggestions on language. If you're writing an offer and the house has solar panels, what to be on the lookout for, what kind of things should you be checking to make sure you're doing right by your client. There were a couple questions about from the seller side too.
Don't buy the house.
What?
Don't buy the house. It's a pain. It's a nightmare.
I know, right?
I didn't mean to interrupt, but oh.
No, I just go ahead, because tell us your horror stories. That's what we're here for.
Every company's different. Some are, and I'm by no means an expert on the actual solar companies, what have you. Some are leased, some are owned. Some have, if there's repairs, the homeowner has to pay for the roof repair when that's taken off. Some that the solar company does. Some have buyouts, some don't. And we're lawyers. I'm not a solar expert. So people are like, can you read this solar I'm like, I think we should probably have you call the solar company, get permission, and get a rundown of what your actual benefits are. Get a history of what the electric uses are, your credits. I've had in this market, the sellers say, I get to take all the credits with me from the solar. So it's like, okay, well, what are we left with? What I write in, or what I write in, it already gets to me when I get there, but I try to, if it's not, I put it in the purchase and sale. If I'm the buyer side, seller agrees to facilitate and sign all required documentation for the transfer of the solar panels to the buyer prior to closing. Usually there's a UCC filing that needs to be released because that has to fall in a second position or subsequent position to the new mortgage that the buyer is going to get. So that's all part of it. I would strongly recommend, if you have the listing, get as much data as you can from the company before right when you list it, because I can't tell you how many times, and we don't know, it's a lot of times, I'm all over the place on this, but in the offer as a buyer, buyer's agent, put in a contingency subject to buyer's review of the solar panel contract and transferability. One, that's good for your client, but two, it's good for the attorney to see that there's a solar panel. I don't know there's a solar panel unless I'm told about it. So what happens a lot of times is we'll make edits that says seller represents they own all fixtures in the property, and then at the last minute it's like, oh, I have a solar panels or a propane tank or something. If it's solar panels, it's like, wait a second, where are all these contracts? We're supposed to sign in 3 hours. We got to find out what's going on. So on the listing side, please, 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 they're very easy to see. No one can't say that they didn't know there were solar panels on the roof, even though I've had somebody try to say that. But please get that information gathered when you list so it can be part of a due diligence package. Just like if you had a condo, you'd have the condo docs. And on the buy side, put in that language that the seller is going to assist in facilitating the transfer of the solar panel contract to the buyer. But for your client, it's very important. And I talk about this in classes I teach. Be the source of the source, right? Like, you don't want to be like, I know you want to be helpful, but you shouldn't be the one calling the solar company and getting the info and then playing the operator game to your client. And then have them call. It's going to be their relationship. Now, again, it's not trying not to do work, but have them call directly. They're going to be the client.
Yeah, your life, your money, your future. And the one thing, it only happened to me once, but to be aware of is that some solar, I think it's all, but I'll just say some that I know of, they will run the buyer's credit to make sure that they are worthy. But what happened one time is the buyer's credit was like right on the line for them being able to qualify for the loan. They've been working on it, they improved it, solar panel company went and pulled the credit, buyer was denied the loan because the credit score fell below the requirement. So like even little things like that, I know it's granular, but maybe talk to the loan officer as the buyer's agent to say, hey, I don't need to know what their credit score is. We're putting something in on a solar panel with solar panels. Is that going to cause a problem? Because that might be the difference between your buyer and we might be pretty far down the line. We could even potentially be like, after mortgage commitment, if in fact, as Brad's saying, we find out about these things very late in the situation, or the paperwork's finally given to us, mortgage commitment has passed, solar panel company 10 days before closing goes and pulls the credit, all of a sudden buyer doesn't qualify, and now we're fighting about whose fault is it that I lost my commitment.
On that as well, you just percolated something in my mind. I had somebody a month ago, so the party's got to facilitate the transfer, and the buyer 3 days before closing says to me, I don't want the solar panels. I'm like, well, you have to take the solar panels. No, I don't want them. Well, just they're affixed to the property. They're coming with the property. But to try to have people understand. It seems so elementary, but it's just trying to let the client know that, and it's not selling against solar panel houses, but really get ahead of that, because they're, they got cool names. I know this is Mark's favorite brand, Tesla or Solar City and stuff like that. They get these cool names and it sounds great and it's green and all that stuff. And maybe I'm speaking for myself, but when I see solar contract on a deal, I'm like, oh, crap. It's a pain.
I think the key is, and the reoccurring theme is to get out in front of it, because there are documents that need to be assigned. There are documents, as Brad mentioned, need to be removed from title prior to closing. That the sooner it happens, the better for our operations departments. I can tell you that. We don't want to be chasing that stuff.
I think, yeah, I mean, and I think what you're saying is, the buyer needs to know what they're actually buying. What does that mean that it has solar panels, on the roof? Like, what does the contract say? I know for myself, as a listing agent, it's, as time goes on, I feel like it takes me more and more time once I have a listing to get all of this information, because these little surprises, come up when people didn't tell you, at the beginning. Maybe I used to say, oh, do you have an alarm system? Yes. Then I find out, yeah, but they don't own it. It's leased. And so now I say, do you own it or do you? And a lot of times they don't even know. They don't know if they own it or they lease it, so.
Propane tanks too, because we always that always pops up. There's no underground fuel tanks. Oh, there's an underground propane tank.
Yeah.
You own it? Nope, I lease it. What are the terms? I don't know. I'm like, all right, well, let's get going on this. We got 5 minutes to sign this thing.
And I mean, most people don't own the propane tanks. More often they're leased. But yeah, that's definitely another example.
That's really, again, I think just being a really good agent is just having that all up front. Like, it's in the listing: leased propane tank, propane heat, propane hot water, whatever.
Hot water tanks, Brockton, Rockland,
lease.
one in Abington.
Hot water tank. Yeah.
Hot water tank rental. I've had people after closing all of a sudden come back to me and being like, they're going to remove my hot water tank. I was like, what are you? That's on one of my solar intakes now. And then it's on, my P&S rider that's like, okay, do they own everything? And again, we all love to think that our buyers and sellers really read these things. I know the attorneys on here, we're like, would you like to review it together? Can we set a time? And sometimes people are like, you reviewed it, we're good. And I'm like, I don't really love that answer, but okay, sure. And then they find out their name's spelled wrong. They're like, where did this come from? And you're like, well, did you even look at your name?
Well, yeah, we all learn as we go along. But that's good advice about the solar panels for sure. The next question is about suitable housing, which you kind of touched on before, but maybe just dive into a little bit more about, probably subject to suitable housing doesn't really cover it the way we need it to. So what are, like I said, your horror stories, and what would be your advice for what should be written instead of that?
One thing I really think is so important is, as the listing agent, when you get it, you've got it listed, you've got suitable housing in MLS. You should, anyways, and you get an offer come in. If I'm the buyer's agent, I'm not going to put it in subject to suitable housing. Why would I do that? When you counter, please put it subject to suitable housing, because if it doesn't, I mean, we don't know. Granted, should we look through the whole MLS every time we do a deal? Yeah. Should we be given more than 12 hours to put together a purchase and sale? Yeah. So if stuff comes fast and furious, if it's not in the offer, is a chance it's not going to get caught. And that is a huge issue for a seller. If they think that I kind of have a get out of jail card here, and then they realize, oh no, you don't have it because your attorney didn't know it existed. That is just like above everything else. Please, please, please let the attorney know at the least, and at the most best, put it in the counter so it's clearly there. The other thing is, do your best by the time the offer signed to define what suitable housing is. Suitable housing can mean so many different things. I have one today, it's signing a lease. I had one yesterday, it's clear to close on their seller's purchase property the day of our closing. I had another one that it was seller has to have a mortgage commitment by X date on their purchase. So it can mean anything to anyone. And I get it. It stinks when you're the buyer and you realize that your seller has all the way till the closing date or the day before to get a commitment or to have a clear to close on their purchase, and the deal could fall apart. But you got to realize that's what you're getting. And to just put suitable housing, it goes back to the appraisal thing, just burying your head in the sand on the appraisal language. Same thing here. It's just going to become a fight between the attorneys that maybe with 5 minutes of discussion at the offer point in time is going to be avoided.
Yeah, call buyers. Call your attorney. We're not. If you don't understand, like, what dates are we looking for, or what terms are we looking for? Like, I don't know what to really say besides suitable housing. Like, I'm going to throw out those magic words, and somehow everyone's going to know. Call the attorney when you're drafting or reviewing offers and say, hey, we'd like to counter. This is what we want, or this is what we need. How do I write this up? And remember, you guys are not limited to those 2 little lines. Like, you can have another document that like further fleshes out what we mean. Is it you have to have a signed P&S by a certain date? Is it this? Is it that? And a lot of times buyers do not understand that the sellers have until closing date to say, oh no, I'm not gonna close. I'm going through this yesterday. Closing date is supposed to be August 20th, but it's also suitable housing, and we got word yesterday because she's like, oh, I wanted to start like doing certain things. They're like, oh, our new construction has been delayed till November. And she's like, okay, well, I'm closing the 20th. And I'm like, no, you're not. Do you see this clause right here? We talked about this. She's like, well, I didn't realize that that's what that meant. And I was like, no, your closing was contingent upon them closing on this house. And she's like, well, I already locked a rate. And I said, well, we talked about this. You were not supposed to lock a rate. She's like, well, they need to pay my rate lock then. I'm like, they're not paying your rate lock. Well, then we need to close and I'll give them a use and occupancy. I was like, you can't give them more than a 59-day use and occupancy, and she kept coming at me. We discussed it. She's like, well, I didn't realize what that meant. And I'm like, I was like, you remember the call, right? She's like, yeah, but I didn't understand that that's what that meant. I was like, okay, well, I can't read your mind that you didn't understand what we were talking about, but sort of thing. But again, it is as exactly as Brad's saying, and I know Mark agrees. Us attorneys fighting it out is just going to delay everything and deteriorate what could otherwise be a smooth and friendly transaction.
So I will add to that also that MAR has a new form for this as well that was released in the spring. So, we respond to the market conditions, and this is something that we were hearing about from a lot of our members. And, they were getting offers or, counter offers that said subject to suitable housing, which means nothing. That's open to interpretation. So now we have a 1-page addendum that is in the forms library that says it's subject to the seller finding suitable housing at the seller's sole discretion. It has a contingency date whereby that seller has to have a fully executed contract to purchase or a lease agreement, and then they have to provide notice by that contingency date or that is waived. So it does exist. So if you've got a seller, looking to use it, you don't have to reinvent the wheel. It is out there for your use, and please use it.
And on the note of what Brad said about saying, what's in MLS and it's not, yes, in our best practice as attorneys, if we have access to MLS, we would go look at MLS, just like we look at the deed or the condo docs or anything else like that. But, another pet peeve of mine is the whole appliance thing. I had 2 yesterday. No appliances were listed in MLS whatsoever. None. So what's included? I don't know. And none of, I didn't see a laundry room. So is there a washer and dryer in this condo? Isn't there a washer and dryer? The condo fees didn't include a laundry facility, but that doesn't mean that there's maybe not, so rather than saying either all appliances, because all appliances, the hiccup with the all appliances, if range, stove, and refrigerator and microwave were included and dishwasher or washer and dryer were excluded, and now it says all appliances. Now, if it says all appliances pursuant to MLS number, blah, 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 then I can say, okay, this is what was included. This is what was specifically excluded. But if you just say all appliances, is the meeting of the minds to the sellers that whatever they were excluding is still excluded? Because I can promise you that the buyers think everything's coming. So take that opportunity in those 2 lines up top where it says property address and what's included to take the opportunity to have a meeting of the minds of what appliances. Is it both fridges? Is the fridge in the garage coming or the basement? Is the sub freezer? Is the wine cooler? Is the, just take the extra minute, the couple keystrokes to include all the appliances. Anything that you guys think is happening needs to be memorialized in that offer. So one, there's a meeting of the minds, and two, when it gets to the attorneys, we can effectuate exactly what the intent was of both parties, and we can get a solid purchase and sale agreement that we're not fighting about either during the negotiations or sometime in the near future.
That's actually a good segue into our next question, which is about inclusions and exclusions, and specifically revolving around, obviously things have changed and now we all have TVs on our walls and they have a bracket that holds them on the wall, and, oftentimes speakers that are either inside the wall or attached to the wall for surround sound. And so this question was about, how do you view that as far as conveying with the property, or has to be listed? And, if there is a transaction and the seller takes their TV and their bracket and there's a big hole in the wall, what have you got to say?
Screwdrivers involved, it's included unless you have specifically excluded it. Bracket stays, TV.
So your thing is the screwdriver threshold.
Like, the screwdriver. A picture on the wall comes off. Something drilled in stays. Unless you've the TV that you can, just take off, not a problem. Unhook a couple plugs, goes. Bracket stays. This is always the fun one. Curtain rod and curtains go. Brackets technically stay. Now, who needs a curtain rod that doesn't have matching brackets? I don't know, but if it involves a screwdriver, I think it's a good baseline to do. If it involves a screwdriver and you did not specifically exclude it, it stays.
So what I like to tell people is, although I might steal the screwdriver threshold line, I really like that. I say, imagine picking up the house and turning it upside down. Everything that falls out gets to go with them. Everything that stays with the property. So, but yeah, we get questions about this all the time. The TV one is a big question. Yeah. But I think now that the mounts are so much more affordable, and like oftentimes it's a specific amount that goes with a specific television. They're not really necessarily universal, that, I probably wouldn't want the mount to stay because it might not fit my TV, but that's something to have a conversation about at the very least. The other thing to think about are like, security systems. So, got Ring or Google Home or Simply Safe or any of these where, you can install them yourself. They're monitored, but they're really just like things that stick to the wall. They're not screwed in. They've got little stickers, or you've got your Ring doorbell, but I've got a specific account to me. Is that going to stay or is that going to go? I think it makes sense to have a conversation and make sure there's that meeting of the minds. And if it's something that's linked to an account, make sure there's contract language that says how that account transfer is going to occur. You've got all these smart home things that some might stay, some might go, but you want to make sure that the previous owner can't still control the thermostat or the security system or whatever, so these, as we evolve and have all these new considerations, it's like you said, Mary, your listing appointment now is so much longer because you have to ask all these questions, but you don't want these last minute questions to come up, right before closing, or even worse, like after the new buyer, takes their brand new keys and walks in and says, oh my God, why is there a giant hole in the wall? I thought the TV bracket was going to be there. One call I got was, in the bathrooms, they weren't vanities over the sink, so they weren't built in. They were just mirrors hung on the wall. So none of the bathrooms had mirrors. The previous owner took them all with him because they weren't fixtures. So, these are things to, as a good buyer's agent, to have an eye out for and ask if it's not clear, and talk to your clients and find out what's important. Maybe they don't like those mirrors and they don't care, but figure it out.
On the smart home thing, I've been seeing a lot of fights over like the Nest thermostats lately. So specifically write out it's crazy we have to do this, but specifically write out Nest thermostats as either an inclusion or an exclusion. Again, it's just because I happens all the time.
There. I mean, how would I know that there's a Nest thermostat? Agents you guys are the eyes and the ears of the house for us.
Well, I think the problem that I've seen is, the house has Nest thermostats and they're screwed into the wall. And then you go for the walkthrough and the Nest thermostats are gone. And these, 1999 Home Depot dial ones have been put in their place. And then, obviously you've got an issue now that you have to solve. And, I think too, some sellers, depending on how the transaction is going, it is better to have that conversation up front. And if you can ask all those questions, what about your Nest thermostats? Are they staying or are they going? If they're going, take them now. Take them now. Is the chandelier from your aunt so-and-so? You're telling me it's your family heirloom and you have to take it. Take it now. Don't show it in the MLS.
And I don't know if it was COVID or what, but the amount of freezers in garages and basements right now. I mean, so please make sure those are, and people get so mad. Just make sure that those are not overlooked. Or
if the transaction
really nice houses, it's not
moved.
plural. There's multiple refrigerators, there's multiple stoves now. There's just a lot there. So.
And I think, Mary, to your point, is to follow up with, you have the conversation today with your sellers, what's coming, what's going. As we get 2 weeks before closing, start reminding them of what's staying, because they might forget, or they might have not even realized that they said that something was staying or going. I mean, I it's the Nest thermostat, that's one. It's the drapery argument, and then it's the washer and dryer that the sellers didn't realize that they were leaving or going, or those are the things that the final walkthrough you get the call and you're just like, it just went my day. Like after work about holdbacks or issues, credits, or where's the moving truck, can we get it back, or and then of course the drapery was always from the Christmas tree shop and cost me $5.
Right, I know. I mean, I did have a closing once where at the walkthrough, the sellers had taken every light bulb.
Yep, that when light bulbs started becoming like $20, that became a very big thing.
And if you've got a lot of recessed lights, obviously if they're LEDs, that's a large amount of money and, a huge inconvenience if you've bought this house and now you have no light, I mean, that was just a contentious, closing where the seller wanted to, make their point. Well, that's all we have time for now because it's 12:30. But I just want to thank all of you for your time, because this is awesome to get all of this info from all of you that are out there dealing with it on a daily basis. And so, Catherine, thank you. Mark, thank you. Brad, Carla,
Thank you.
I really appreciate it. And, have a good rest of the day. And, if anyone on the webinar has any questions, let us know. I mean, you can still always email info@southshorerealtors.com and, they'll channel it to wherever it needs to go, or you can reach out to one of the panelists. And if you have any great ideas for forms for MAR, bring them on, because Catherine's right. They're creating these forms to help the membership. So, if there's a need and there's a problem out there, feel free to identify it, and they'll see what they can do. So with that said, have a great day, everybody.
Thanks, everyone.
Thank you, everybody.
Bye.
Wow.